Hi, my name is Ben Cote and I'm an attorney at Stiles Law in Marshfield, Massachusetts. I focus my practice on several areas, including residential real estate, commercial real estate, and estate planning. Stiles Law is not your typical law firm, and I'm not your typical lawyer. Most people think of their attorney as a technician that simply reviews contracts, prepares documents, and holds formal meetings. While that's definitely part of my job, I think I'm most valuable to my clients when I provide strategy, advice, and insight into their own situation. You're watching the first video in a series in which I will attempt to provide a blueprint for how I approach legal issues. I'll almost certainly cover black letter law and the technical side of my job, but my hope is that my viewers will be able to take my thought process to help think through their own situation. In this video, we're going to cover some of the most basic concepts in real estate conveyancing. What is the process of making an offer? Purchasing real estate starts with a contract. A contract is simply a legally enforceable agreement between two or more parties. Under Massachusetts law, a contract to purchase real estate must be in writing to be enforceable. And in most cases, this is called an offer to purchase, or shortened to offer. I say in most cases because it is possible, especially when purchasing commercial real estate, to submit what's called a letter of intent. This is something that we'll definitely cover in a future video. An offer has several elements. The most obvious is price, but others can be equally, if not more important. There will always be a time for performance, as Massachusetts law requires a firm date and time on which title will transfer. The offer will also state who the buyer and seller are, in addition to who will hold deposits and what contingencies may apply. A contingency can be thought of as an out. The most common is a financing contingency. In this case, the buyer's obligations are contingent or conditioned upon getting financing from a lender. If the condition is not met, the buyer is permitted to terminate the contract and receive his or her deposit. The offer will also say that the buyer and seller will sign a mutually agreeable purchase and sale agreement. A purchase and sale agreement, or P&S for short, is a longer contract that fleshes out the details of an offer. So for instance, the offer may not go into detail as to what may be deemed clear title. Don't worry, we'll cover that in a later video for sure. The P&S makes the buyer's and seller's obligations as explicitly clear as possible. This would be difficult at the offer stage, as it would require the parties to analyze long, complex legal documents ahead of even coming to basic terms like price and dates. So let's look at a typical process. Usually a buyer will meet with his or her broker and write up an offer. The broker will often provide guidance on what's customary. So for instance, how long between the date that the offer is signed and the closing date. After the buyer is satisfied, the buyer will sign the offer and his or her broker will deliver it to the seller's representative. The offer will state that it must be accepted within a certain period of time. Without this clause, a seller could legitimately wait years before accepting the offer and binding the buyer. The seller's representative, whether their broker or real estate attorney, will review the terms of the offer with the seller. If the seller agrees, he or she will sign the offer and return a copy to the buyer. The buyer and seller are now said to be under contract. If the seller does not accept, there are a few options. First, the seller could do nothing. This is common, especially when the offer is much lower than the listing price. Second, the seller could reject the offer. This is the equivalent of just saying no and nothing else. Finally, the seller could submit something called a counteroffer. This is the equivalent of saying no, but... And if the seller returns a counteroffer, sometimes shortened to if the seller counters, the buyer now has the power to accept, reject, counter, or do nothing with that offer. They're essentially in the same shoes as the seller was. Let's assume, for the sake of argument, that the buyer accepts the offer. Congratulations, you're now under agreement. The offer is a legally enforceable agreement and prevents the seller from selling the property to anyone else and obligates the buyer to go through with the purchase. So what's next? To find out, you're going to have to watch my next video. If you enjoyed this video, please hit the like button. If you didn't, leave me a detailed comment and let me know how I can do better. Please subscribe to be notified when my next video is available. And most importantly, thanks for watching.